take that off. My name's Andrew Williams, and I'm a professor of law at the University of Warwick. And I've been fascinated by the UN War Crimes Commission work for many years now, and how it connects with contemporary military law and international humanitarian law. But it's not about me today at all. It's about our three speakers, or at least two, if Dawn's here now. Less about me and about the presentation. So Dr. Carl Yip will be our first speaker, and then followed by Dawn Stedman, and Regina Paolozzi is, I hope I pronounced that correct. Probably haven't, but shall we start straight away with Carl, and then it'll be 15 minutes. So I'll try to keep time fairly strict, if that's okay. So we've got plenty of time for conversation and discussion afterwards. So you'll have 15 minutes each, and I'll put my hand up and wave if it gets close to that time, if that's okay. Pretty blunt way of doing it, but hopefully effective. So Carl, can I ask you to launch us into this session, please?
Sure. Thank you very much, Professor Williams. I've got some slides to share with you also. And I'm very happy to begin this panel because I'm very much a beginner to the research on the UNWCC archives. I hope that everybody can see the slides.
Yep.
Fantastic, yeah. So because the focus of my research is actually neither history nor international crime, so I'm very much a beginner. I've got a little interest in combatant immunity and sort of its history or its historical reflection or manifestation in the post-World War II era or the World War II era. And it grew out of my PhD research, and which is actually about the use of force against individuals in war in general, and the laws that govern. And I suppose criminal lawyers would be interested in asking what makes certain conduct wrong in war. I'm a bit more interested in the other side of the question, what somehow makes certain conduct right in war, and in what sense do we mean it? So when I talk to people about, this interest, slightly historical, people sometimes don't understand what I'm talking about or why I would be interested in this topic. It somehow falls through the crack. So I look forward to learning from you guys and to sort of connecting with other interested people. I also saw a phrase yesterday from a blog post about the crack between jus ad bellum and jus in bello, and I thought that it kind of aptly describes the issue of combatant immunity. I'm sorry, I just need to. So because it refers to those conducts that sort of we now know, in our contemporary times, know that it refers to the conduct that doesn't violate jus in bello, and at the same time it's kind of neutral as to jus ad bellum, because so long as you're not in a leadership position, then the sort of normal acts of war or warlike acts don't really constitute crime as such, or that you won't be prosecuted as such. So that's a contemporary understanding of combatant immunity. But looking back in history, its origin is not so certain. On the one hand, there is the uncertainty about individual responsibility for even violations of laws and customs of war. I'm sorry, I have a title there. So even violation of law of armed conflicts pre-World War II there is some uncertainty about individual responsibility in foreign courts because of the active state doctrine and functional state immunity. And on the other hand, there is also some uncertainty about individual responsibility for what we now call aggression in the old days, the crime against peace, whether that was in fact even criminal pre-World War II. So those kind of, doubtful sort of origin gave rise to two alternative characterizations of this notion of combatant immunity. One is that it's a procedural concept, that it is merely a type of what the sort of wider concept of sovereign immunity. So soldiers are basically state agents, and they basically carry with them state immunity. What they do officially, even in other states, are sort of either acts of states or somehow covered by functional immunity. And so even if they violate the national laws of the enemy country, they won't be prosecuted. So that's a procedural view. The second characterization is a substantive characterization, which goes perhaps deeper in the sense that it felt that the law of armed conflict simply changes the boundary or the scope of what can be regarded as criminal in war by, for instance, providing for a substantive justification or defense to the acts. And these are basically normal acts of hostilities or warlike acts. So these are the two alternative characterizations, and in contemporary sort of literature, there are adherents to both camps, or either camp. So the Law of State Immunity textbook would say that immunity of armed forces present on the state's territory is usually a function of consent given by the territorial state. In an armed conflict, that consent will obviously not be granted, and any applicable immunity then becomes a function of acta iuri imperi principle. Okay. And it's not sort of restricted to people in sort of immunity field, but an IHL lawyer would also say that, or some IHL lawyers would also think that immunity from prosecution for military personnel belonging to a state was and still is the normal result of sovereign immunity from prosecution for violation of national crimes of another state. On the other hand, you've got the repertoire for the ILC working group on immunity of state officials, who think that the issue of criminal prosecution and immunity of military personnel for crimes perpetrated during military conflict in the territory of a state exercising jurisdiction was seen to be governed primarily by humanitarian law and to be a special case, and should not be considered within the framework of this topic of immunity. And also some other IHL lawyers would also think that the rule of functional immunity belongs to the law of peace and was therefore abrogated upon the outbreak of war. Conversely, the rule of combatant immunity belongs to the law of war and was therefore triggered upon its outbreak. So these are the kind of, different characterizations that we have in contemporary times. During my research for my PhD, I came across several kind of practices in the UNWCC's work, also more generally national practices that I thought are kind of illuminating or kind of suggestive, and I wanted to share with you and see what you think. Oh, well, but before that, there are obviously, hybrid characterization as well, that, criminal jurisdiction of states is primarily territorial, and state officials don't usually exercise their official functions in the territory of other states. An important exception is during an international armed conflict. IHL has provided that these officials should not face criminal prosecution at hands of the enemy states solely for their involvement in such hostilities, as long as they adhere to the laws and customs of war. such immunity is removed as soon as the rule permitting the exercise of extraterritorial jurisdiction over that crime and contemplating prosecution of state officials develops. So that's just an alchemy of both sort of procedural and substantive concept. But let us look a little bit at the practices. Some jurisdictions, I think Anglo-American primarily, they would charge people on the basis of violations of the laws of war directly without reference to the national law. So bypassing any references to national laws. So for instance, this is a proclamation, I believe in 1944 or something like that. This is from the President that all persons were subjects, citizens or residents of any nation at war with the United States will give obedience to or act under the direction of any such nation and who during time of war enter or attempt to enter the United States through coastal boundary defenses and are charged with committing or attempting or preparing to commit sabotage, espionage, hostile or warlike acts or violations of the laws of war shall be subject to the laws of war and to the jurisdiction of military tribunals. So whatever they do, so long as they're enemies, they would be subject to the laws of war. Okay. So I would think of this as more of a procedural model because it confers kind of direct jurisdiction on the states to try only those acts or to convict those who've actually kind of violated the laws of war without references to the national criminal justice system or the criminal law of that territorial state. The UK practice is somewhat similar, basis for the trials of alleged war criminals by the British court with, under this royal warrant in 1945, to charge war crime as a violation of the laws and usages of war committed during any war in which His Majesty has been or may be engaged at any time, blah, blah, blah. So again, a direct reference to the international law of armed conflict. Dutch practice has certain similarity. The Special Court of Cassation stated that international law should not be looked upon as a justification for the acts of a state which had itself disregarded international law in occupying the Netherlands. This is basically a rejection of the idea or of rejection of the substantive model of combatant immunity. That is, it doesn't actually serve as a justification. But there are also certain sort of passages in trials or practices or legislation that would support a more substantive model. In the hostage case, there was this passage that it can't be questioned that acts done in time of war under the military authority of an enemy cannot involve any criminal liability on the part of officers or soldiers if the acts are not prohibited by the conventional or custom rules of war. And then French practice was even more prominent. They got so basically all of the, I understand from the archive that the French trials basically proceed by or start by kind of examining the case first from the perspective of national law first, and then they try to see whether there may be a justification under international law that can be used to, by the defendant to kind of, to defend themselves. So, and there is this French ordinance in 1944 that says enemy nationals or agents of other than French nationality, blah, 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 shall be prosecuted by French military tribunals and shall be tried in accordance with French laws in force and according to provisions set out in the present ordinance, where such offences, even if committed at the time or under the pretext of an existing state of war, are not justified by the laws and customs of war. So I wanted to kind of share with you a few sort of implications that I kind of derived from these lessons or these incidents or references.
Carlock, please.
Sorry?
You have about 1 minute, if that's okay.
Okay. So yeah, this is the last slide. So in a procedural model, jus in bello doesn't justify or permit. In a substantive model, jus in bello provides justification, but only in relation to individuals for their criminality or criminal charges. For both models, jus in bello cannot legalize whatever is prohibited by other bodies of law. For instance, jus contra bellum, human rights law. I'm particularly grateful that Professor Willems is chairing this panel because he's a writer on the Bahamusa case, and he would know all about the sort of human rights implications of these wartime violence. So I'm grateful for your attention, and I look forward to hearing your comments. Thank you.
That's great. Thank you very much for wrapping up expertly on time. I think the way forward is to have all three presentations first, and then we'll take questions afterwards and perhaps get the discussion going. So Dawn, can I ask you to launch into yours, and Carlock, if you would stop sharing your screen, and then Dawn can take over. Go ahead. You're muted at the moment, but there you go.
Hello. Yeah, sorry. Thank you. Apologies for being a few minutes late when we started. Connection issues as ever in this new internet world and blended world. Okay, so hello. So my perspective in all this is looking at it from a defence point of view, or from the defence's point of view, and I'm generally beginning a project looking at defences and how they are defined and used in international criminal law. And so this was a fantastic opportunity with this call to look at another aspect of defences that are equally kind of under-examined. So generally defence is under-examined in ICL, but I think that would be so with the United Nations War Crimes Commission as well. I mean, it is itself under-examined, but also this particular aspect. So really, this is preliminary. So I'm looking very much, I'm beginning to look at this project. So I'll be very grateful for any observations or any suggestions that anybody has. I think also, I mean, I'm familiar to an extent with the international military tribunals, as I think we all are. They're kind of the more famous tribunals of the time, but there's far fewer of them in number. And I think what the UNWCC offers us is an opportunity really to look more widely at a range of defences that are deployed, and also particularly the reasoning as to why these defences on the whole failed. Mark Ellis earlier mentioned about how there are almost 25,000 individuals who were prosecuted, to give you a sense of the scale. Amina said, what, 2,000 trials, something like that. And of that, about 1 in 5 were acquitted, but there were many more that exercised defences, or at least attempted to, but were unsuccessful. My focus for today, though, for reasons of time, and as I say, also I'm at that preliminary stage, is to really look at how the defences have been reported in the official reports, so the 15 volumes, the initial 15 volumes that were the official reports. And so I'm using that as my kind of source for today's talk. But I would very much like to go on and look at more of the cases more generally. Before specifically just talking a little bit about how those defences have shown themselves in these official reports, I just wanted to pause to appreciate the wider recognition. Again, something that I hadn't appreciated in the jurisprudence that came out of the WCC, it's an awkward acronym to say, recognising the right to fair trial. So, and that very much is a part of the right to raise a defence, or defence, the ability to raise a defence is very much part of this concept of fair trial right. So the trials themselves occurred, I think it's worth remembering temporally, they occurred either just before or contemporaneously with the advent of kind of modern rights recognition of the right to fair trial. So they are happening at roughly the same time as negotiations and agreements in relation to the Universal Declaration of Human Rights, the American Declaration of Human Rights, the negotiations for the European equivalent in terms of the European Convention. So the fact that there is a strong support, focus and recognition of fair trial rights within the case law, particularly looking at the Elstotter and the Fleisch cases, where they were not just looking at how rights were not respected by the defendants in those cases that then led them to find them responsible for the particular crimes that they were accused, but also trying themselves to ensure they were enjoying some kind of trial rights as well, and defence rights within that. Characteristics that they identified will be really familiar to us today, given our understanding of what fair trial rights would contain. But at the time, I would say it's innovative. It's kind of really interesting that they identified something that we today almost take for granted, that we just assume it's part. So, for example, the right of the accused to know the charge against them, reasonable time to prepare for the trial, and obviously to prepare a defence for that trial, to be tried by someone who is unprejudiced, to know the evidence that is against them, to be able to have some kind of counsel as well. So all these things that we now just accept, at that time in the 1940s was very much a part of what they were identifying as would be a correct trial, that the defendants, one, should have respected themselves in the roles that they held, but also that they would have that expectation too. And that very much corresponds, just to finish up this kind of broader contextual point, about the contemporaneous reports or accounts of the trials that we see. So the International Law Quarterly, which I think is the precursor to the ICLQ, and the American Journal of International Law, both in contemporaneous accounts, spoke about the establishment of this particular, the Commission's work, and emphasised the centrality of justice within this post-war multilateral project. The idea that you should develop this doctrine of individual responsibility, and that within that there should be a just result. So there should be kind of fair recognition in terms of fair culpability, so allowing for people to be able to raise a defence if they should have one, to examine that more closely. So this idea of a just result is part of that kind of central philosophy. And then as I say, we saw that in a couple of the cases explicitly drawing that out. So to go to the main point, how widely then, within this kind of context of hoping for a kind of just and fair process, how widely were defences deployed? So if we use, as I said, the official reports as an indicator, about a quarter of the cases that were reported in those reports did raise defences, and they were one out of this was the case of Weiss and Munder. They were the only ones who were successful in raising the defence that they did. They were accused of the war crime of wrongfully killing a prisoner of war, and the facts are very straightforward. So essentially the victim was an American parachutist captured in Germany when his plane broke, so he had to obviously parachute down from his plane. He was handed over to the local police, who were the two defendants in question, so Weiss and Munder, and when those two police officers were bringing him in, they found themselves surrounded by a hostile crowd, hostile to the enemy parachutist. The POW, the parachutist, moved suddenly. The police officers, alarmed at this, thought he was reaching for a weapon because he hadn't yet been searched, and so they fired. And this is the one example in the official reports where a defence, obviously here self-defence, was recognised and accepted by the courts, that they were felt to have acted reasonably and necessarily, and used the correct level of force in order to be able to protect themselves. This, as I said, is exceptional. It's the only successful one within the reports. There is another very similar example of self-defense is attempted in a very similar way, again with another airman who had to leave his plane very quickly, found himself in Austrian territory this time, and under the watchful eye of a local member of the local defence force. Again, the parachutist appeared to reach for his jacket, as was reported by the local defence officer, but in this case, the self-defence claim was rejected, was not accepted, because the defendant shot him both as he faced him and also as he ran away, and so it was that double effect that caused the self-defence to fail. So two examples there, but only one where there was success in terms of exercising defences, and that generally defences were not found to be credible or were not accepted by the court. So as I say, there was just that one example within the official reports that I've looked at, though obviously there are many more cases, just to use that caveat. So what kinds of defences were raised? So obviously I've mentioned one in terms of self-defence, but there were a whole range of them, and often they were used in combination with one another, so they weren't used exclusively. So special superior orders was the one that was most commonly deployed or most commonly referred to, and actually that bore out a fear that as part of the negotiations had been identified that this would probably be a strategy that was used by the Axis officers in terms of it would be a common defence that they would try to deploy. I was just following orders. Other defences that were used were ones related to necessity, related to coercion and duress, as well as more technical defences related to, say, the non-applicability of war crimes to civilian defendants, violations in terms of nobis in idem and legality, and also the existence of national law as a legal justification for the actions at the time when they did them. Finally, there was one example of intoxication being used as a defence. As I said, some of these defences were raised in combination with one another, and about half of them related to superior orders. Superior orders as a defence, as I say, is this idea that you would have authority because you're following orders. So the higher authority has given you the permission to do what you did. Prior to the Nuremberg Tribunal, Robert Jackson did compile a report on superior orders and raised questions as to how it would affect culpability, and came up with essentially the conclusion that up until that point, when he was compiling a report in the mid to late 40s, was that the norm raised in international penal law that inferiors should not be held to account for acts ordered and conceived by their superiors. And so that was the point, particularly up until that point he identified, but he said that it had caused, this particular absolutist approach to it had caused some disquiet after the First World War. And so it was felt perhaps that there should be a change in the conception of superior orders, that rather than the evidence of superior might allow a court to decide whether acquittal is appropriate or not, but they would have to take into account other things such as the level of compulsion, membership of a criminal organisation, and the nature of the act itself. The point that he makes about compulsion is one that we'll return to towards the end, because we'll look a little bit at the defence of necessity, which has an impact there. But essentially the approach continues to this day. So this is also me trying to think a little bit about how was it conceived, for example, using Jackson's report, and Professor Lauterpacht also has something similar as well, and whether that's remained to this day. And essentially it's this idea that superior orders would not be an excuse in terms of responsibility, but could be used in relation to mitigation and sentencing. So it doesn't exculpate. Further observation in one of the cases is quite interesting in superior orders. So just to finish on this point about superior orders, which generally were not accepted by the courts in the official reports that the cases that I've looked at, is a particular comment that's made in relation to the justice case. So this was a case that involved defendants who were connected to their employment at the Ministry of Justice within Germany. The defendants had a whole range of capacities. Some of them were judges, and some of them were prosecutors, and some were more administrative within that Ministry of Justice. But the point is made in relation to judges themselves, where it says the superior order defence does not sit well with a judicial office holder, given that the nature of that office, being a judge, is that you should exhibit impartiality and independence. Very different to where the concept of superior orders came from, or the justification that it should be accepted, which is within the constraints of a hierarchical organisation, which relies particularly on that sense of obedience to follow an order, particularly in a conflict situation. So there was almost, you could hear this in the judgment, this kind of even less sympathy for a judge trying to rely, as they did, on the superior order defence because of the nature of the very role that they had. So I thought that was interesting, that was felt like kind of an extreme too far in terms of where it should be applied or to whom it could be applied, and almost the cheek of suggesting that you would do that. Anyway, so superior orders, and then finally, if how am I doing for time? I don't want to overrun.
You've got a minute.
Have I? Okay, well, instead of, I was going to talk a little bit about intoxication. It's always interesting, but instead, let me just move to the point about necessity. So just to conclude, because it ties back with something that Jackson said. So another defence that was raised was the one related to necessity. And there was an interesting case which involved a captain of a U-boat who had returned to the debris and the life rafts that his U-boat had caused when they had blown up a ship, and he had then sought to destroy, kind of return and destroy all that evidence. And it was to avoid detection from an overhead aircraft being able to see that there was some kind of destruction, and that then might lead them to understand there was a U-boat in the area. So he did it on the grounds of essentially military necessity, because to protect his crew. This argument was not successful, in part because it took him 5 hours in order to make this decision and to destroy everything. And the court quite reasonably said, you know, the operational aim to save the ship and the crew was fine, but it could have been achieved much more effectively by speeding away at the greatest possible distance without such acts of cruelty. So again, it's kind of speaking to that idea within necessity that you're kind of balancing considerations. But what they did say in the Peleus case is that they could foresee that it might be possible for there sometimes to be a military justification for proceedings, I mean, military necessity for proceeding with a killing, that it was accepted that that might be the case. And this reminded me a little bit of Adamovich, because essentially it comes back to that idea of that question in relation to what necessity is essentially arguing about, and duress, you know, the related ones, so duress of circumstance or necessity, is how much resistance can the law reasonably expect an individual in a particular circumstance, particularly the circumstance of conflict. And this is kind of recalling a little bit of what Jackson said about that level of compulsion. So in the Adamovich case, it was the individual, this was a Yugoslav case that involved an individual who was very young at the time, who was part of a firing squad, and he had disquiet about this. He was really concerned by this, and so the commander's response was, we'll go and line up with the victims then. And so he remained a part of the firing squad. And so this idea of this necessity of circumstance, this level of compulsion, which Jackson is hinting at what point does it absolve you from or excuse you from responsibility in terms of the actions that you're doing? And I think that Adamovich, we saw with that case, is that there was a wrestling in the court about where that line should be drawn. So I think that I would like to go back and have a much closer look to see, because it does seem to be a defence that is raised a fair amount at the UNWCC, to see the reasoning that's being presented, if it can illuminate us further in terms of kind of where that line should be drawn. But so yes, I realise I won't do a neat conclusion, so I'll just say it has been fascinating to look at these defences in the first instance. I think there's a lot of questions that it raises, and it's such a rich vein, so I definitely will be going back to have a look again, but I welcome your questions and thank you.
Thank you very much, Dawn. That's really interesting. Lots of questions I've got anyway from both presentations, but particularly that one. But before we get to the discussion, Regina Paolozzi, I think, is that the right pronunciation?
No, I'm not Italian. It's Regina Paolozzi.
Oh, right. Okay. I apologise. I hope I
No, you're fine.
sort of murdered the name in that case. Yeah. But you've got 15 minutes, and be really interested to hear your presentation, and I'll put my hand up and wave when we're getting close to the end. So
thank you.
Over to you.
Thank you. So I'm only going to take a few minutes, because I tend to, and I'm sure many of you can relate to this, when we're given a little bit of time, we tend to go off on tangents and then we lose what we're trying to do. So I was really, first of all, I want to start off by thanking Professor Adnan and her team and everybody else who's been working with her on this. I was very excited about this call because it is very rare for somebody like me within the international criminal legal field to see a call that really is based on history. And I think we have gotten to a point in the practice of international criminal law specifically, and I guess in these contexts, we're talking about war crimes, but actually if you look deeply into these archives, we see a lot of mention of crimes against humanity or crimes against peace. And what happens is we tend to divorce ourselves from the historical context, and we're starting to get into trouble a little bit, I think, in the interpretations of what we're finding. And we tend to think, oh, it's never been done before, but it has. And so some of the points that I'm going to make today may raise some eyebrows, but I think that's good. That's what the space is for. And I'm hoping I can do more of that as we go along. So thank you to her and everyone else who's put this on for bringing this diversity, and especially within this context of this topic. So what I want to start off by saying is that my colleagues and I, Lina Lorinaviciute and Ronald Rogo, we wrote a paper, a chapter actually, in the historical origins of international criminal law in 2014. And that chapter, you know, traditionally kind of made people question a couple of things, because what we basically put out into the world was that the Nuremberg trials were really not where we start when we talk about international criminal law. In fact, where we really need to start when the advent of international criminal trials and these, I was listening to both of the speakers before me talk, is we're actually looking at the military trials from the time of World War I. And that really lays the basis for this. So in this chapter that we wrote, and it's open source, so anybody can access it, we discussed the fact that there were these tribunals that were set up, one inside Germany, one inside in Turkey, what is now Turkey, and these trials continued, and they were run by the British and the Allied powers of that time. And we see for the first time a lot of these kind of concepts that now emerge in international criminal law that we use. So for instance, the idea of universal jurisdiction, the idea of military or superior orders, and how fair trial should be, and individual responsibility for criminal activities. And there's a lot of discussion in World War I that happens. And so I want to make 3 specific points about that, and then I want to open it up for questions and answers, because I think that's where we get a lot of this from. But what we conclude in our paper is that this is really the starting point when we think about international criminal law. And Lemkin, Raphael Lemkin, when he talks about genocide, he says that it's not something new in human history when we talk about genocide. It actually has happened over and over again, but we end up codifying it into law around the time of World War II and thereafter, when the United Nations and everybody's up to speed on why it was important. And even then that was politically negotiated, not really what he wanted. So the first point I want to make is that in the archives that we're looking at, what I found was really interesting was that the legacy of World War I and these specific military tribunals that happened with regards to the Armenian genocide, massacres, crimes against humanity, whatever you want to label them, they actually are found throughout the archives in different places. And just yesterday, when I was poking through them one more time, because you have to be very careful when you do the search, I found a whole discussion about the International Criminal Court. And what I thought was interesting about that is that they talk about the fact that in World War I that this discussion started happening, but we don't see the codification or the actual birth of the ICC until what, 2000, into the year 2000, right? In the 90s, they start talking about it again, but this was all discussions that started happening around that time. So what I would say is that the archives actually present a picture that is missing, and that picture can be complemented by what I'll make in my third point. But my second point that I want to make is that the trials of World War I, because our position is that they form the foundation of international criminal law, is that those trials actually, when you look back and you revisit the history of that entire situation and the trials of World War II, those military trials, what you'll find is that the discussion, and specifically that document I found yesterday, is that Nuremberg and the trials that happened around World War II were another version of what international criminal justice could look like. So we have one version after the Armenian situation happens, in which we have these tribunals set up inside the country so that the public can have access to them. We have perpetrators being tried. We have amnesties given suddenly by the Allied powers, so that way they can just end the trials because they were more interested in getting POWs back. And then we have World War II happen. And now we have more discussions about crimes against peace, and we have war crimes and all these kind of discussions happening. But the question is whether or not those models were going to be used again. And I think that's the kind of place where we're missing information, and why these discussions about history are important. Because what we find later on in our history, in our most recent history, is when we come to tribunals like the ICTR, those models really aren't built on Nuremberg. They're built on the Armenian military tribunal trials, and the fact that we would take certain concepts and build regional mechanisms, or as we see more and more, the use of universal jurisdiction, being able to try people even if they're not in the location where they are. Because as we know, Germany wasn't really a big player with the Ottoman, they were a big player with the Ottoman Empire, and they were also where some of these military tribunals were held in World War I. And then the final point I want to make is that I think that the UN work, this archives needs to be complemented. And I think there needs to be a concerted effort by states as they release their documents. I know in the United States, there's a certain period of time in which documents will get released and put into that, but I think the archives need to be complemented with a more holistic picture. So I think what's happening is that as we dive into these archives, we should be leaving with more questions than answers, right? Because it's not a complete picture. So if I want to find out, about civil rights history in the United States, there is another set of archives I have to go look at, but it's not all under this UN War Crimes Archive. And there's, very little about World War I, but enough for us to know that there is a gap in the archive. So I'm very excited because what I've been able to do is look back at the paper we wrote in 2014 and determine that the existence of these archives really do prove the fact that there were trials that happened before that, and that they were utilized as a source by the powers that be when they come to the World War II tribunals. So I think I'm gonna leave it there because when I went digging into the archives, I found other points and other things that I got inspired by that have to do with other things going on. So I don't wanna go off on any more tangents. So thank you.
Thank you very much indeed, Regina. That's really, I think, an important reflection to bring us back to the fact that whenever we go into archives, there may always be antecedents which are extremely relevant. And actually, I think the UNWCC did understand that and bring it into play. And we can talk about that a bit more. I'm sure there are lots of questions for those three presentations. We've got about half an hour. So can I open it up to the floor, please, for anybody to raise any question? If you want to, can you raise your hand and put your camera on? And maybe if you're able to, and then maybe we can get the discussion started. A flood of responses. Anybody got any questions? Dawn, yeah.
Can I ask a question of Regina? Is that
of course?
Is that all right?
Yes,
are we allowed
absolutely,
to do that?
absolutely.
Yeah. Fascinating. Thank you, Regina. I'm curious to know what the more holistic picture would be. So what else would be in there if we're thinking about the UNWCC, for example? So I entirely agree with your point that looking at the archives raises lots of questions, and I love the idea of it being a more holistic archive itself, but what would it entail?
Well, I think one of the things, and maybe this is just to get more at it, I think we need to get the other tribunals that happened before World War II to understand the basis. So you had mentioned Robert Jackson's report on the orders, but the British prosecutor Hartley Shaw in the military in Nuremberg, he makes references to the military tribunals that happened as a result of those crimes, right? So we're missing probably the archives in Turkey, which slowly they're only allowing limited access to. I think some of the US archives need to be put in there. And really it's probably, again, every state has its own document retention and release policies. So I think the issue is how do we coordinate that better to get all those out there? Because I think enough time has passed where both countries can release some of those things. But in the case of the Armenian situation, we do have still a very contested situation as to the labeling, right? So I think that's one of the bigger issues that's happening there.
Yeah, thanks very much for that. I mean, one aspect that I wanted to raise on that as well was the impact of the Leipzig trials in the early 20s, which flowed on from the First World War, which were generally conceived as being a failure from the British perspective anyway. And certainly I've seen in the archives, in the British National Archives, communication and between civil servants, influential civil servants, that when discussing the prospect of military tribunals at the end of World War II, saying, we don't want to go there because Leipzig showed us what a failure it would be, both of politics and justice. And therefore, any form of tribunal that follows on from these kind of precedents would be a disaster. They were overruled eventually by the Americans, but there was a very strong anti-trial provision within the UNWCC by the British. So I think that's part of that picture that you're talking about. The Armenian tribunals and what have you were much more difficult to access, and of course the British weren't so interested in that, not necessarily for good reason either. But yeah, that's really interesting to see that as a connection. Have we any other questions? Yes.
I just
sorry.
wanted to add on,
Regina,
Professor
yeah,
Williams, that those failures, though, I mean, even if the British characterize them as failures, they're important because they do set a standard in which we know where we're growing from and where we need to go with it, because they do come back. I mean, all of this does come back eventually in some form, right? So, yeah, I agree with that analysis.
Yeah, absolutely. They need to be taken into account because they did prompt that possibility, both at the time in 1917, 18, but also later. And they were desperate for precedents to give them that sense of let's get these trials underway. Once, particularly the Americans and Robert Jackson had identified the structures. But yes, I don't want to dominate any questioning. Anybody else got any questions? Well, I wonder if I can bring in something then of yours, Dawn, and one of our Leonard Paulson. Hi there. Are you there? My camera off, but he is. Yes. Hi, Leonard.
Hi, Andrew.
Good to see you.
Good to see you.
I wanted to sort of draw you in because of that practitioner perspective on the idea of defence. And I was really interested in what you would see about what Dawn was talking about in terms of the defences that were produced, and whether it is true to say that the first line of defence would be putting to proof the prosecution, which was a consequence of this adoption of an Anglo-American fair trial model, and if that and that may be part of the reason for the 20% of acquittals across the piece, rather than discrete defences being successful or otherwise, that it was just that failure to prove the prosecution's case beyond reasonable doubt. And I wonder whether, Leonard, as a practitioner today, whether you would see that as probably the primary defence, as a sort of negative defence, or in that context. So it might not be surprising we don't get much in the way of sort of specific defences.
I think that's correct too. I think there's more to it than simply putting the prosecution to defense. I think it has more to do with narrative as well, and coming up with a counter narrative, which is very important, especially in international cases. My experience in terms of putting up a defense in different tribunals and in different arenas around the world, different courts, is markedly different. And it all depends on what you have to work with. If the rules of procedure and the environment in which you work is of a certain standard, such as the ICC or the ICTY or things like that, then you have something to work with. If they're of a standard where there's no specificity of charges and there's no wiggle room, there's no scope for the defendant to know precisely what he's charged with, so therefore no scope to actually carve out a decent defense, then it becomes much harder. And we've seen things like that in Bangladesh, for example, in the international tribunals there. From a defense perspective, you have paradigms as well, prosecutorial paradigms like the joint criminal enterprise and the extended from the joint criminal enterprise, which again has now changed. And you're up against it a little bit as a defense advocate. There are, and I agree, putting the prosecution to proof is probably the key strategy and the overarching strategy. but it needs to be more than that. And every case is complex, it's nuanced, and it depends on which tribunal you're appearing before.
That's excellent. Thanks for that, Leonard. Lovely to see you again after so many years.
For those who don't know, Andrew was my personal tutor at Warwick, and this was, I think, the year after he was voted as the best teacher at the University as well. So
don't embarrass me, Leonard. Too many years ago. But yeah, I think that's a really interesting point about the different circumstances and context that talking about international criminal justice has to take into account. And I think, Regina, that sort of buys into that sense of holistic view. Is not just necessarily the history of a particular strand of international criminal justice or military justice, if you like, but actually flowing through different jurisdictions at different times, that they bring with it that difficulties of developing defences in different contexts. And I wonder, Dawn, whether you had you thought more about that sort of sense of the connection between the Anglo-American model and the kind of defences that you've been seeing as either being effective or ineffective in the trials that you've looked at.
I mean, I need somebody who's perhaps more knowledgeable on this than me, but from my preliminary understanding of the UNWCC, there was a process quite of case selection by the various authorities that were prosecuting these cases. So it might be that when we talk about 20% acquittals, actually that's a bit of a false figure, because for those cases where either the proof wasn't there or the defense was overwhelming and that had already been decided in the kind of the case management process before we'd even got to the trial, that maybe actually there are more defenses that we get. But how do we access that information, you know, that almost administrative kind of pre-trial information? So maybe the 20% is a figure that we should be cautious about, perhaps. So that might be my initial, but you're right. I hadn't considered that idea that, I mean, because the majority of cases that are in the reports are either English military courts or American military courts, who will obviously come from that tradition. And we've seen this in today's practice of international criminal law, that it is heavily influenced by the background of the judges, particularly who are hearing the case, whether it has a more kind of civil process and interventionist process versus a more kind of criminal law process, the common law process. So I think that is a really interesting question that I need to actually think a little bit more about. Yeah. No, thank you. Yeah.
Yeah, that's great. I wonder if, sorry, Leonard, yeah, please.
Just offer an example, just basically on what Dawn said about the different types of, you have civil, you have common law jurisdiction, all being fused into an international court, or bench, or a panel of 3 judges usually. And if one of the judges, and I remember this from experience, starts harassing a defense counsel, it wasn't me, but it was another defense counsel, on the art of and the virtues of cross-examination and how it should and shouldn't be done. And obviously there's a huge gap as a practitioner, depending on which jurisdiction you come from, as to what you are not allowed to do and how you're allowed to put questions to witnesses for the prosecution. It's very clear what the rules are in, for example, in the UK and in common law. You put your case, and you challenge theirs, but that's not always the way forward. That's not always the way they do things. In example, in the civil jurisdiction, where you have prosecutorial investigative judges and things like that. So it gets very tricky. So that's a good point, which Dawn just made, which I just wanted to augment from my own experience.
Yeah, that's really interesting. Those different cultures of legal process and legal technique. I think we tend to see it in sort of Anglo-American forms, and of course that is just one prism to consider international criminal justice. And if you're looking at international criminal practice, particularly today, then that requires a degree of understanding of different contexts and jurisdictions, for sure. That's a really important insight, I think. And I wonder, sort of trying to draw Karl Loch back in terms of your review and research, whether looking at the different jurisdictions, the French and Netherlands and what have you, in terms of whether other jurisdictions, whether you picked up on that sense of different cultures, legal cultures, creating different senses of how to do justice.
Thank you very much for raising this, because I was actually sort of, thinking of the same question when I heard this discussion. And indeed, I mean, if you recall the examples that I gave, the French practice was certainly, they put more emphasis on their own national criminal law process than the Anglo-American practice, which seemed to be more open to directly implement and enforce international law at the domestic level. Whereas the French practice was more sort of geared towards, first of all, getting through the hurdle of their own law, and then use international law to kind of supplement by providing defenses or justifications, that sort of thing. So one could see that. But I mean, I would welcome other people's thoughts on other civil law jurisdictions. I haven't actually come across that much materials, and I have to granted I haven't actually done very exhaustive research on the archive itself, but I would be interested to know what other people might have looked at, particularly, in terms of the laying of the charges. What's the first step? Do they go through the national criminal law first, or do they actually directly implement international law?
Okay, I don't know whether it's worth bringing Amina in here, whether you've got a perspective on that, because obviously you've been looking at these issues very carefully.
Thanks, Andrew. I was actually just, when I was listening to Karl Loch there, I was thinking how her point relates to my research. So how, as far as I understand, in terms of the legal basis for the trials under the UN War Crimes Commission, was that you had Control Council Law number 10 that was created by the Allied powers, and that was viewed as, that was the law that gave the basis of the foundational jurisdictional scope for the trials to take place. Now that was viewed not as international law, but as domestic law, and that's why it goes broader. It's broader in scope in terms of it removed the nexus between, for example, crimes against humanity and international armed conflict that existed under international law at that time. So it removed that, and it was able to do that because it was viewed as domestic law. And then what happened was, so each allied state, it was up to them how they criminalized the crimes that were listed in Control Council law into their own law. So some states, for example, did that by creating like military orders. So the likes of the US, they created these orders by their supreme commanders. And then you'd other countries such as, off the top of my head, some of countries like Norway, and some of the European countries, they chose to base their laws in national law, rather than like using military law to establish their tribunals. It really was done on an ad hoc case by case or country by country basis, because there's a lack of uniformity in terms of how Control Council law was implemented in each of the allied states, of the member states of the UN War Crimes Commission. And then even at that, when the member states had incorporated Control Council law into their laws, however, which approach they decided to take, then it was up to them what crimes they then prosecuted and what sort of procedures they include or they created in their trials. So some countries created like military commissions to try the crimes, such as the US. Other countries use their national courts. So I believe the Netherlands did that, and some other European countries did that as well. Again, it was very much on a piecemeal basis for each member state. So that's in terms of my knowledge, in terms of the legal framework for the trials, for the creation of the tribunals and how they operated. As far as I understand as well, there was a process by which the UN War Crimes Commission decided like what, first of all, they gathered evidence on accused persons and then decided what would be prosecuted and what would not be prosecuted. But I'm not entirely familiar with that process. I think Dan Plesch would probably be a bit, he'd be more of he's an expert on that and how that all operated. So you're better off asking that question to him. Thanks.
Thanks, Amina. Yeah, I mean, has anybody else got any questions or comments on so far? Carlock, yes.
No, I wasn't raising a question.
Oh, sorry.
Clicked mute.
That's okay. Okay. I just wanted to go back to that defence thing, and I was asked a specific question of Dawn again, but and I think your point about the 20% being a sort of a fiction, because obviously it depended upon the determination of which cases to pursue in the first place, and clearly, if you look at the investigation files, which didn't end up in the UNWCC archives, but are in the National Archives of the UK and the US, I think, those investigation files are still there to be seen, and you can see the cases that didn't pursue to trial for one reason or another. And those decisions were mostly made, I think, but on the basis of, was there sufficient proof to bring a case? So that sense of evaluation of evidence was very much part of that case building that one would see as a sort of a normal process in the criminal justice system of the sort of common law approach. But I don't know whether you've seen or looked through the Bergen-Belsen case, because there you've got a sort of distinction early on from the later cases, in the sense that Bergen-Belsen and the 1945 British trials were British advocates. They were British lawyers who were appointed as defence attorneys. And then slowly in 1946 afterwards, defendants could bring their own attorneys who, in the case of the West Germany, were German lawyers. And there you got some development of defences being more thought through, rather than the putting to proof aspect that Leonard was talking about as well. But that Bergen-Belsen case did throw up some defences that were tried, and particularly about the quality of evidence that was provided. So there was a reliance on affidavit evidence, where the witnesses had long since gone, because they were released from the camp and they were never tracked. And as a result, the affidavits which talked about particular wrongdoing was therefore suspect, because there wasn't a possibility to cross-examine. And there you see the development of one of the international criminal law principles, which is that you can accept evidence that you wouldn't necessarily accept in a normal criminal common law jurisdiction fair trial. So there's sort of manipulation of what we see as fair trial, not only in terms of its development along common law lines, but also its restrictions and its finessing. And there might be some interesting stuff there. But I did want to ask about the intoxication case, because I wasn't aware of that. And it's too interesting to just leave. So we do have a couple of minutes, and I want you could just briefly tell us about that case.
Okay, so It was fascinating because it's the only time that it's mentioned, at least in these official reports. I mean, obviously it might be elsewhere, but also, you know, intoxication, when I teach it to my students, they're always fascinated by it. I don't know why, but they always are. So as a defense, but it was raised once, as I say in the reports. It was a Japanese army sergeant who was the defendant in this case, and he was charged with killing a civilian who he had believed had stolen some provisions of rice. So had come into the army stores and stolen some rice, and there was not just one individual, there were a group of them who had done this, and there had been previous examples of looting as well of the army stores, and he claimed both intoxication and self-defense. The self-defense was not accepted at all because he was the only one who was armed, and they disregarded that very quickly. But they looked a little at the idea of the intoxication and whether that would be possible to be a defense here. But essentially what they did, and it's interesting to hear what Carlock said there about relying on the, you used the example of the French and relying on the domestic. So in the intoxication case, that's exactly what, it was a British court that was hearing this, and it's exactly what the British court did, is that they went and looked at beard, which if anyone has taught intoxication in English, England and Wales, knows that that is still a case that we talk about in relation to intoxication. So they used the authorities, the English and Welsh criminal case law as the authority of understanding the effect that intoxication can have, particularly when can it be a defence. And for anyone who's aware, very rarely. I mean, the English courts are very suspicious of intoxication being raised as a defence. Essentially, if you are involuntarily intoxicated, it will be permitted, and that's actually been reflected in international criminal law today. It's kind of it's found in the Roman statute, but also essentially, if you can't form the requisite intention, if it's a special intent, a very complicated form, then it's possible then for intoxication to be used as a defence. But essentially, if you can show that you had the necessary intention even when you were intoxicated, then you will be found responsible. So in this particular case, that's what the court decided. So they looked at the evidence that was presented by the defendant, and they came to the conclusion that he knew exactly what he was doing. There was evidence that of an individual who gave a witness statement against him, one of his former colleagues, who said, you know, he liked to drink, but he never got drunk. And so that was essentially used to say, you know, he clearly had the requisite intent, so therefore he could not rely on intoxication. But again, it is an interesting example because it is so rarely raised in international criminal cases. So it's just fascinating to see a court go through the process of trying to understand, well, what's the relevant law? How do we understand this defence to be? What are the limitations of this defence? And because we have so little other material to rely upon, it's just interesting to have that as an example to kind of fill in that gap of how it might be perceived today if it was explored in an international court.
Yeah, that's really interesting. Thank you. And I imagine that claim was brought by a British lawyer appointed.
Yes, yeah, exactly. Bird, can I rephrase Bird? Yeah.
Yeah,
exactly.
And that was very much the sort of style of the early trials. Was that sort of what was familiar? And I think it goes back to Leonard's point as well. It's not just about the jurisdiction you're working in, but the jurisdiction you've qualified in, and what kind of defences and precedents hold water when it comes to actually presenting them in an international tribunal, which obviously was a problem in terms of the management of these trials across Europe, because different bodies were trying from different cultures. And I think it probably comes back to Regina's point, really, in many respects, in the sense, if you look holistically, you have to take into account these different traditions all operating at the same time, and sometimes in contradiction to each other. So there's some fascinating comparative work, I think, that might come from this examination of the archives, of which the UNWCC provides some, but not necessarily all of them. And it sounds like a rich field to pursue. Okay, I think we've exhausted our time. So I just want to thank all three speakers very much for fascinating questions and subjects, bringing them to our attention. And thanks to everybody who's thought about this and taken